It is July 11th of 2026, and this is the Court Gallery. Coming up, a defendant tries to justify posting someone else's private photos online, but her bizarre logic forces Judge Simmons to deliver a masterclass in accountability. Then, we jump into a family court hearing where father gets so frustrated that Judge Hesselink has to tell him to sit down and be quiet before he finds himself in contempt. And you will not want to miss the end, where defendant tries to explain her situation to Judge Wilcox by claiming she's a Rothschild. Her mother is the infamous hijacker D.B. Cooper, and the FBI is very, very interested. All that and more starts right now.
State of Michigan versus Alexis Yurden, 25-3476. She must have been advised prior to that this was going to be dismissed. Okay. Does she have an attorney?
Yes, Your Honor.
Oh, Mr. Okay. Have your appearance, please.
Ross Martin on behalf of the people.
Dan Doyle on behalf of Ms. Yarden.
Okay, Ms. Yurden is scheduled today for final pretrial. I do have a nollie for this case. People are moving to dismiss without prejudice due to lack of necessary witness, correct?
Yes, Your Honor. Mr. Doyle represented me that his client intended to flee, but I can't in good conscience take that plea knowing that we would not be able to proceed unless the witness appeared on Zoom without me knowing. I have not been able to get a hold of her. Of course, we have the right to reissue, as everyone is aware.
So, in case you didn't hear that, Ms. Yurden, they do have the right to reissue this case against you, okay?
Okay.
Mr. Doyle?
Oh, wait, hold on.
I was going to say,
It sounds like the witness is here. I called her.
Victim. I'll say victim.
Okay, I apologize. It sounds like the witness is here.
Oh,
So,
victim is in the courtroom. So there was an offer?
yes, we made an offer in which she would plead guilty to count 2 with dismissal of count 1.
And Mr. Doyle, how is your client proceeding?
my client will be pleading guilty. There was also a killer group for no upfront jail.
Yes, that is correct, including the agreement to no upfront jail.
And this is a recent change in my courtroom policy. Please have to be in person now. I am going to allow her to proceed via Zoom, but she'll appear in person for sentencing. Well, actually, I can just sentence her today because she does have the victim. I just need to give her criminal history when David returns. Okay, so Ms. Yurden is going to plead to count 2 of, is that dissemination of sexually explicit material?
Yes, Your Honor.
Okay, is that correct, Ms. Yurden?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I do.
Thank you. Okay. And you're sitting in a car, you're not driving, correct?
Right.
Okay, and is anyone else in the vehicle with you?
Not at the moment.
And so you understand that the offers for you to plead guilty to count 2, that the people will dismiss count 1, and that there is a killer rule, which is a sentencing agreement of no upfront jail. You understand that?
I do, Your Honor.
Yes.
Okay, and so in order for you to accept that offer, you would have to understand all of your rights, and then you would have to be willing to give all of those rights away. So you have the right in this matter to the presumption that you're innocent. You can maintain your innocence and take this matter to trial and require that the prosecution prove each element of the charges beyond a reasonable doubt. You understand that?
I do.
You have the right to see, hear, or question any witness called to testify against you, the right to have witnesses subpoenaed on your behalf, to give testimony on your behalf, and the right to remain silent, and silence cannot be used against you at your trial. Do you understand that?
No, I do, Your Honor.
Are you willing to give up each of these rights today?
Yes.
Anyone threatening you to do that?
No.
Has there been any promises extended to get you to give up these rights and plead guilty to count 2?
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
You understand that by pleading guilty, it could result in a conviction that you may need to report to your current employer, or you may need to put this on a future job application.
Yes, Your Honor.
This also could result in a conviction that may prohibit you from travel or immigration status that you may be seeking. So you may want to go out the country somewhere, and that country may deny you entry into their country due to a criminal conviction. You understand that?
Yes, Your Honor.
As to count 2 of intentional dissemination of sexually explicit material, how do you plead?
Guilty.
Is that because you believe you are guilty?
Yes, Your Honor.
Mr. Doyle, you can water your client.
Yes, Your Honor, thank you. Ms. Jordan, on or about July 10, 2025, at the location of 2 Lansing, Michigan, do you recall that date?
I do.
And what did you do to make you guilty of this offense?
It actually wasn't on that day. I believe it was like June 28th, June 27th,
Okay.
that time.
Yes.
And I shared a picture that she had sent my fiance and creepers, and then her naked picture, and then her face on my story on social media.
Okay, and she didn't give you authority to submit or post her nude photos on social media?
Correct.
And you agree that she's above 18 years old?
Yes.
Yeah, and I believe that's sufficient for a factual basis.
Any questions from the prosecution?
I apologize if this was asked. Did this happen in the city of Lansing?
Yes.
The people are satisfied with the factual basis.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. Any objection to immediate sentencing?
No objection to immediate sentencing, Your Honor.
Does your victim want to make a statement?
Your Honor, the victim does not wish to make a statement.
You can make allocution.
Yes, Your Honor. I would just indicate for the record that Ms. Jordan is taking accountability for her actions. She's a single mother of 5 children. She's been in therapy since this incident. She's getting over a toxic relationship, toxic and abusive relationship. But nonetheless, she's taking accountability for her actions in this case. I'll just ask that you take all that into consideration.
I mean, Your Honor, if I may be heard, I would just say, obviously it's not lost in the court. This is a very serious crime, even though it's not reflected as such in severity given to it by the legislature. It's the kind of thing that's humiliating to a person and just never fully goes away. So I would request that the court consider that.
Does your client want to make a statement?
Ms. Jordan, did you want to make a statement?
I do, Your Honor.
You can do so at this time.
I would just like to say that I did commit this crime, and I do understand that is a serious offense. I am not the same person, nor am I in the same space that I was when I did this offense. I was in a very, very toxic and a very, very, very abusive relationship that I am currently pressing felony charges against my ex-fiance for. And that is why the victim has waited several months to even press charges, is because it is in retaliation to this case and is punishment for me trying to get free and have safety from him. I do believe that everything being done is a direct correlation to what he is telling her to do and what she is being directed to do by him, to punish me for standing up for myself. But
Let me interject because I'm very lost because based on your factual basis, this was your fiance, and you said that there were pictures that this woman sent your fiance, and now as you're making your statements, it doesn't. I didn't think when you said that it sounded accountable, but it definitely doesn't sound accountable now. Who is the victim to this person that you allege to be your ex-fiance?
I am the victim.
No, no, you're not the victim. You are the defendant.
I mean, no, not in this case. What
No,
I'm
I'm
saying
talking
is,
about in this case.
okay,
Who? Yeah. What relationship does this? Is Miss Riggle?
yeah, she's his
With?
ex-wife.
Okay. Okay. So she is his ex-wife. They were not married at the time of this alleged incident. Is what you're saying?
Correct.
Okay. And they have children in common.
They don't.
They do not.
No.
Okay.
Him and I have a child in common.
You and him have children in common. Okay. And so your belief is somehow that this case is stemming from her attempts to retaliate against you.
Correct.
Retaliate for what?
Because I am pressing felony domestic violence charges against my ex-fiance for two violent, ferocious beatings that he did that we are currently also going to court for.
So what does that have to do with Miss Riggle?
Now they are back dating, and
How do you know?
oh, she comes to all of the court hearings and stuff when I am subpoenaed to go to for my other cases, and he tried to bond out to her house. So she comes.
You were at court and you heard him try to bond out to her house?
Yes.
Okay. And so because of that, you formulated in your a belief that the reason why she's pressing charges for you putting her nude photos on public social media is all because you are now an alleged victim in another case. Not because you put her private body on social media.
I would just like to point out that the pictures were posted in June.
I don't want you to point anything out to me. I want you to answer my question. Because I'm trying to get you to understand what you're saying makes no sense.
Okay.
Would you like it if someone put your vagina on Facebook?
She did, Your Honor.
No. Did you like it?
I didn't care, honestly.
You don't. Oh, you don't care? Okay. Well, the average woman cares. The average woman has enough self-respect that they don't want their private body parts publicly exposed for any reason.
Right, so, and I understand that.
I'm happy to hear that you are in some counseling, because if you don't care that someone would post your private parts on social media, then you really got to do some deep soul searching. So I don't think you're at a place where you can take accountability, because I don't even believe you're being honest about whether or not you care that someone posted your body on social media.
I mean, I took the plea deal. I'm telling you that I did it. I'm telling you the correct dates that it happened. I'm taking full accountability. I'm also just giving you the full scope of.
But you're also justifying. When you justify your behavior, this is retaliation. You're saying that's retaliation. You have now gotten into the mind of Miss Riggle, and you are now telling me what she's thinking.
Due to the late charges being filed, I do believe that it's.
You know what the victim is thinking.
I don't. I'm just giving you my perspective, Your Honor.
Yeah. So my perspective is, regardless of whether or not it is true that she is pressing charges because she's now upset that you are pressing charges against whoever this wonderful gentleman is that you all are arguing over, I disagree. I think that this behavior is egregious. And I think that you should be more focused on the fact that you found yourself in a situation where you were creating this energy, and you're going back and forth, and you're now taking a criminal charge, and it all stemmed from you being in a relationship with someone that you clearly should not have been in a relationship with.
And I realize that, and that's why I've been going to therapy. I'm completely trying to put all of this behind me. I don't care about any of them. I just want to be done with the entire situation, which is why I'm taking the plea. I stated I'm not that person and I'm not in that spot anymore.
Okay. Are you employed
I am
full-time or part-time?
full-time.
Okay. I'm going to order her to do 8 months probation. While on probation, you're not to have contact directly or indirectly with Ms. Consuela Riggle, okay?
No problem.
You're not to engage in any assaultive or threatening behavior. You're not to be at any bars or nightclubs. You are required to maintain employment and provide evidence of that to probation. I am going to order for you to participate in anger management group and provide evidence that you are seeking counseling. I am not going to order her to undergo any testing, Mr. Doyle, at this time because I don't see where this had anything to do with alcohol or substance. It has to
Yes,
do
Your Honor.
with. Okay. You're not to possess any firearm, ammunition, or weapons of any kind. Do you have any questions about your probation at this time?
How soon do I report to the probation office?
So you're going to come in within the next 48 hours to go see them in person because you're not here today. Normally, I would send you directly down there
Okay.
to check them. So you'll also be able to report monthly via Zoom, okay?
Okay.
Lastly, there's fines and costs, a $75 crime victim rights fee that must be assessed with a $50 state minimum cost, but also must be assessed. Probation is assessed $30 per month for oversight fee. So if you do 8 months, that's $240. Your total fines and costs will be $365, and we'll make monthly payments on that, okay?
Okay. If I want to pay it all tomorrow, can I do that at the probation office too?
You can absolutely pay it all tomorrow if you would like. And then I was going to also advise you that you do have the right to request early discharge from probation once you've completed half the original term ordered by the court. So 4 months in, if you have complied with my order and participated in anger management and that there's been no violations of your probation within 90 days preceding that request, you can make a request using the court's MC 512 form. That's on the court website, or you can get it from your probation officer. If you file that request, you have to file it with probation, and then you must serve a copy of your request on the prosecutor's office. The prosecutor has 14 days to respond in writing to any objection to your request for early discharge, okay?
Okay, ma'am. Thank you.
No problem. If I set it for a hearing to address your request, you have the right to hire an attorney to represent you, but you do not have the right to court-appointed counsel for any hearing for early discharge. I have never held a hearing for early discharge. I have typically reviewed them off the record, okay?
Okay.
Do you have any questions at this time?
No, Your Honor. Thank you.
Okay. Any additional matters for the record today?
Nothing for the people.
No, Your Honor, thank you.
Thank you. You are all set. Don't forget to check in with our probation within 48 hours, okay?
I will not, ma'am. Thank you.
Thank you.
Our next call is a matter of People versus Randy Christine Stout. This is filed for 24-4972 FH.
Brian Ziegler on behalf of the people.
Thomas Seagull, paying with on behalf of the Scout.
Thank you. Ma'am, are you Randy Christine Stout?
Yes.
We're here for sentencing today. Did you have enough time to go through the PSI with your attorney?
Yeah.
Enough time to go over it?
No, sir.
Mr. Seeger, do you have corrections, additions, or deletions?
I do not, Your Honor.
The guidelines are accurate.
I do.
Mr. Seeger, do you have corrections, additions, or deletions?
No, Your Honor.
Do you believe the guidelines are accurate?
Your Honor, the court had addressed at the last hearing the scoring of OV-19 and said that we should be prepared to address OV-19 at 15 points.
You should.
I agree that OV-19 is properly scored at 15 points based on the court's comments at the last hearing and based on the history of the case.
Yeah, 10 points, you mean? So my understanding is 10
I'm sorry.
scored for the interference or attempted interference with the administration of justice here absconding for over a year. 15 points would only be if there was danger to a penal institution.
Correct. Yes, 10 points, Your Honor.
Mr. Seeger, did you wish to be heard on the scoring of OV-19?
Your Honor, I would agree that just I would ask if there is a case that specifically addresses it, then I would ask the court to cite the case if it's going to change it. However, just as a rudimentary reading of it related to other cases that are somewhat similar in nature, I would generally agree that probably 10 points can be scored. It would change the range from 0 to 17 to 2 to 17.
So the court notes that OV-19 is scored when I find that there's interference with or attempted interference with the administration of justice. There's not just one case, Mr. Seeger. There's literally dozens in the Court of Appeals and the Michigan Supreme Court, which have found that a party's absconding for any amount of time is in itself attempting to interfere with the administration of justice. The administration of justice is the court being able to impose sentence on a felony offense that the defendant pled to. Here, the defendant pled guilty to a felonious offense, and it was set for sentencing, and then she failed to appear. Bench warrant was issued 2/5 of 25, and she absconded and failed to allow the court to administer its justice, its business, for a year and 3 months. So I'm not citing any specific case. I'm citing the proposition that absconding for well over a year is the exact definition of the statutory terms of interfering with or attempting to interfere with the administration of justice. There are many cases which support that, but the court's not required to cite cases in support of its rulings. It's entirely appropriate to simply rely on the factual assertions that are contained within the PSI or that are known to the court. So OV-19 is scored at 10 points, and therefore it is a 2 to 17 guidelines range because the OV level does jump up to 2 with 10 points total. In terms of the background of the PSI, did the attorneys, either one of the other attorneys, have any corrections, additions, or deletions?
No, Your Honor.
Yes, sir. Mr. Ziegler, did you have elocution?
Your Honor, Ms. Stout has done herself no favors in this case. In 2024, she had 2 cases for possessing narcotics. She pled guilty to this one in January of 2025. The people did not pursue the other one. Instead of appearing for sentencing and, in my view, likely getting a probationary sentence or maybe a brief jail term, Ms. Stout decided to abscond until May 24th, 2026. On that date, she was caught in a vehicle with almost 2 ounces of methamphetamine and paraphernalia in her vicinity. According to that police report, she told Sergeant Schaub that the meth belonged to her. While I appreciate her honesty in that case, her behavior in skipping out on sentencing for almost a year and a half, while clearly still engaging in possessing controlled substances in significant quantities, cannot get a pass. Her guidelines are 2 to 17, which are an intermediate sanction cell. There is a presumption on an intermediate sanction cell of no jail, but that presumption can be overcome, and I think is clearly overcome in this case. The defendant clearly has no respect for the law or for the authority of the court and has chosen to ignore her sentencing date and to continue to allegedly violate the law. If she then were to insist on hiding behind the presumption of no jail, I think that would make a farce of the criminal justice system. The defendant needs a harsh penalty for violating the law and then skipping out on the consequences of violating the law. A sentence at the very top end of the guidelines is warranted to send a message to her and to others now and in the future. Appearing at sentencing is not optional. Thank you.
Thank you. Mr. Seeger, on behalf of Ms. Stout.
Your Honor, I would likewise agree that appearing at sentencing is not an optional consideration for any client or any attorney or anyone else that's ordered to appear when they're ordered to appear. Be that as it may, Your Honor, the explanation is that Ms. Stout was dealing with a very significant substance abuse problem. And inasmuch as it's easy for us to say, well, there's a piece of paper that says that you need to appear on a certain date, or there's a piece of paper that tells you that you need to immediately discontinue using substances because it's a condition of your bond, is not entirely realistic. The part about showing up when you're required to is definitely realistic, but the order related to conditions of bond, saying you need to comply with the conditions of your bond and no longer use drugs when you've been using them for an extended period of time, and you clearly need to be entered into some kind of treatment, is not probably particularly reasonable. It's reasonable to order it. It's probably not particularly realistic that somebody is going to be able to discontinue a substance abuse problem that they have had for an extended period of time. And I think for Ms. Stout, there came a point wherein she continued to struggle with her substance abuse problem. She was unable to turn herself in during that time period because it would have been difficult for her to detox during that time period. She was trying to address many of the other personal issues she had together with her own substance abuse problems. I don't use it as an excuse, Your Honor, because clearly it's not an excuse, but it's just rather it's an explanation. Mr. Ziegler had referenced that when she was apprehended, she was in possession of certain other prohibited items. That matter is set for trial, and we're likely to have a trial absent there being a resolution. To the extent that the court wants to take that into consideration at a later date following trial, I guess the court can take that into consideration, but I would not ask the court to take that into consideration in advance of trial, because there's not been even a preponderance of evidence determined, at least as it relates to the other factual allegations and its conduct that will be judged at a later date, either by resolution if she enters into a plea, or by trial if she's either acquitted or convicted of something. I don't find Ms. Stout to generally be a bad person. I find her to be a person who has struggled with substance abuse. She expressed to me that she wants to remain clean, she wants to remain sober, that she wants to get into treatment if that were a possible option. But I think, like many people, she was just struggling through life. And unfortunately for her, as opposed to perhaps members of the court or other people who have more standard living or have more standard occupations, it's easier for somebody who is in a position where they don't have substance abuse problems or they don't have financial issues to cast stones about, well, you should do this or you should have done that, when we're not living their life, because I don't have to worry about where my next meal is going to come from, and I don't have to worry about paying my light bill or how I'm going to get to a substance abuse treatment facility or where I'm going to live the next day. I have those opportunities. And it's not to say that a stout does not have other opportunities to try and rectify her ship. But I think the circumstance in life has been different based on the people that she's been associated with for years, based on her own living standards, and perhaps based on many of the choices that she once made that became addictions for her in later years. In any event, Your Honor, she understands that the court is likely to impose sentence. She understands that the court was not pleased that she failed to appear for sentencing. She's just asking the court to impose a sentence within the guidelines, and she's hopeful that the court will allow her to get into treatment at some point in time, which would be in everyone's best interest, including the general public. In as much as I do understand that the court has to send a message, but also one of those messages may be that the court is not always entirely harsh and not looking to destroy people's lives. It's also looking to allow people to address the problems that brought them into court in the first place, because I don't generally want to see my clients again, other than to maybe run into them somewhere in town and say hello. But I clearly don't want to run into Ms. Stout again dealing with another drug file because it continues to have a problem. If people don't take advantage of that programming, if they're afforded opportunities and they don't do particularly well, that's somewhat on them, but I still want to give them the opportunity because I don't want to give up on people who are making choices that are not, at least in my mind, malum in se, they're malum in prohibitum. They're something that they shouldn't be doing or they're prohibited from doing by statute, but are not inherently wrong. And although I continue to think that using drugs is an entirely bad life choice, it's not my life to make decisions for them. And that is implicit in the idea of liberty. In any event, Your Honor, she's just hopeful that the court will give her a reasonable sentence. And at some point in time, whenever that may be, will allow her to get into drug treatment, which I think is in everyone's best interest.
Thank you. Ms. Stout, was there anything you wanted to tell me before I impose sentence?
I know I absconded for bond, and I know that wasn't right. I shouldn't have. I wasn't in my right mind. But yeah, everything Steve said, I would just like the opportunity to prove, I guess, the law different, and I have a good support system. But yeah.
What arrangements have you made for treatment?
Well, because of the other case going on right now, I thought I had to be sentenced on both cases before I could get into treatment. Otherwise, I would have already started the progress.
So you haven't made any arrangements?
No, because they told me I have to have 45 days, and then I'd have to redo the intake again for treatment. So I was waiting till this other case because a lot of people were telling me that I couldn't go.
So I've taken a chance to review the entirety of the PSI. I'm obviously familiar with this case. I presided over it. To be clear, I take no personal affront to the fact that you absconded for over a year. It's a factor that I have to consider, however, and it's a factor that does you no benefit. It does you much harm. So the fact that that happens does not mean the court has a personal affront about the circumstances. You're entitled to do whatever you want, but you need to also bear in mind that what you do has then actions and consequences. The consequences for not only fleeing the jurisdiction of the court for over a year, but then being caught with 2 ounces of methamphetamine apparently and telling the police that he possessed it and owned it. And while I do consider those things, I'm entitled to consider all of those things because they're part and parcel of how you got back into the court jurisdiction. So any argument suggesting that the court shouldn't take that into account is disregarded by the court. It is accurate that you're entitled to a trial on that in terms of a different preponderance, a different standard of evidence, proof beyond a reasonable doubt for hearing whatever you're charged with. But that's not the standard I'm dealing with here. What I'm dealing with is a preponderance of the evidence. And I know from getting a booking sheet that said you were arrested, and I know by preponderance of the evidence from what the prosecutor claims, and he has access to police reports that I don't, that there are circumstances which convince me that you were in violation of the law at the time you were arrested on this offense, and being in violation of the law by allegedly possessing with intent to deliver meth. That's also contained in the PSI. At the time you were arrested, you had 2 outstanding bench warrants, one in Roscommon, one in Kalkaska, or the delivery of meth or possession with intent to deliver. All of that is not only fair for me to take into account. If I didn't take it into account, it would be a significant error, because I have to take into account everything that's in a PSI, everything that's in your favor and everything that's not. Would you have appeared at the sentencing hearing back in February of 2025? It would have been very likely that you served less than probably 47 days in jail that you've already served in this offense up to this day. But that's not the circumstance that we're in now, because you were outside of the court's jurisdiction. That enhanced your guidelines range from 0 to 17 to 2 to 17. And you were over a year absconding, and you picked up new charges. New criminal behavior, absconding. You weren't charged with that, at least that I know of yet, but you certainly could have been charged with absconding. A 34-year-old being sentenced on a 3rd felony, 4 prior misdemeanors, is a circumstance where really straight jail is the only reasonable answer, and a lot of jail because of the circumstances. Again, I don't have on this record anything to suggest, other than your attorney's words, that you are serious about getting into treatment or changing your personality or your background with addiction. Perhaps you are, but I haven't heard it. And so I don't take that into account as a significant positive impact or a positive rehabilitative potential. Perhaps it's there, but it's not been explained to me in any way. And so with that backdrop, I think a 10-month jail sentence is important. It's important to send a message to you. There's punitive actions and there's repercussions for when you fail to appear. It's also still within the guideline sentence. And any presumption, as the prosecutor articulated, that there is for a non-jail sentence has been thoroughly rebutted by your actions. In this case, of absconding bond, of committing new criminal offenses, of having bench warrants, and otherwise being only 34 years old, being sentenced today on your 3rd felony. So for those reasons, a 10-month jail sentence is imposed. Credit for 47 days that you previously served. Crime victim assessment will be assessed at $130. Court costs of $325, and attorney's fees of $350 and the $68 state costs. By state law, those fines, costs, and assessments are due today. If you don't pay them within 56 days of the date, it's 100% on. If you have the ability to ask for leave to appeal, you can sign the appeal rights, fill out the copies, and turn them into the court if you wish to ask for leave to appeal.
And Your Honor, just for the record, she's executing a copy of her rights. You won't give it to the appeal. Thank you. Should be done next now. So,
I'll leave them.
Court calls case People versus Matthew McLean.
This is on behalf of people, Your Honor.
Anybody make a decision?
Yes.
Thank you.
Stephanie Canna on behalf of Mr. McLean. Please state your name for the record.
Matthew McLean?
Your Honor, your approach.
If you must, yes. All right, record should reflect we've had a bench conference in this case. Go ahead.
It's fine. It's come to my attention that Mr. McLean has not been directly contacting the victim, but I have come to find a few jail calls that concern me and what she's telling his family members. Tell her that he loves her, as well as also mention to those specific family members who he's trying to get to be in contact with the victim, that if she does not show up, that the case would be dismissed, and suggesting things of that nature to them as well. So I have concerns, given that at first it's just to reach out with my love yous, but then it's also suggesting outcomes that could interfere with this criminal case. So at this time, I'm going to be asking that the defendant be remanded, and that text privileges in the jail where you want to give it.
And Your Honor, in response to that, there's been no evidence presented whatsoever that any information has been communicated to the complaining witness in this case. And just because he has knowledge of how things typically go in this matter and has expressed that knowledge is not indication that he has been trying to tamper with the case or the witness in any way, shape, or form. He's not in communication with her now. He's very concerned about her right now. I told the court, and that's because there's been no communication whatsoever. She has been on repeat calling his family, and there'll be evidence of that if we do proceed further, trying to see what she can do to get the case dismissed. And that's evidence that we are going to be presenting to the court, and her taking culpability for the incident as it happened. I understand the prosecutor's position. And my client since then has not made any communication, reached out any way, shape, or form. Matter of fact, when he came in, because she has stopped communicating with her family and his family, he wanted to know if it was okay to call to get a welfare check on her because he knows her mental health status and her drinking status. Your Honor, my client has, as soon as he got out, he went and checked himself. He went into the Don Farms outpatient program.
And I'm accepted for inpatient.
Into their inpatient program because he understands that a part of this incident stems from both of them and their sobriety and challenges with sobriety. So as soon as he got out, he came in and told me this is what he was doing, and I told him that's really good.
I have an official letter.
And so he is trying to fix this and straighten it out. He is aware that he cannot communicate with her directly or indirectly, Your Honor, and he will not be doing so.
Yeah, but they're repeated indirect calls. As I indicated to counsel, the concern sometimes when you get the I love yous, that can be concern. When you get the wanting to check on somebody, can be a concern. I don't know that from the court's perspective that is such a concern, but when you start talking about how the case to these same third parties about that, basically if she doesn't show, then the case gets dismissed. And you're telling them in essence to communicate certain things to this person, that becomes a problem. And he shouldn't have been doing it in this case, or certainly have made it clear he shouldn't have been communicating to third parties about her anyway. Some of it might be able to be excused, but I can't excuse that. So what I'm going to do is I'm going to adjourn the probable cause conference to.
Oh, Your Honor, we were asking for the exam to be set.
Okay, then it won't be addressed till the 21st, if that's what you want me to do. Otherwise, I'd give you a week, the 16th, your choice.
The 16th, Your Honor, we'll take the 16th, Your Honor.
I'll adjourn probable cause conference to July 16th, 2026, 9 a.m. At this point, given what the court has heard, defendant's bond is ordered revoked, defendant's remanded. Court does call the case of the people versus none. Where is she? Please, thank you. Your name?
Good afternoon, Your Honor. I am Bakaina.
Thank you. People have put their appearance on the record. Well, you may go ahead.
Yes, okay. Good afternoon, Your Honor. Robin McCoy on behalf of Mr. Mackay Nunn, who stands to my right, P63057.
All right. This is your motion regarding bond.
Yes. Okay. Yes. So just so the court is aware, I know when I was last here, I did not have the discovery. I did receive the discovery, the paper discovery. I reviewed all of the paper discovery. I would note that there is reference to a video, which my understanding from Madam Prosecutor is that they're working on getting video. As I said in my motion, Mr. Nunn, and I've known him actually all of his life. His mother worked in our office for about 10 years. His father is here. He has two sisters here, a girlfriend, and I think it's a cousin that's here. He is gainfully employed, and he has an apartment. He has no prior record, no juvenile record, nothing of the sort. As I reviewed the discovery, and I did see there are some discrepancies, and there's some things that we obviously need to look at. We are asking that.
Mean discrepancies.
Well, discrepancies, I did see what the prosecution wrote in their response. The fact that when I was reviewing the report, it said that he was not under arrest and he was questioned, and he says he was never Mirandized. And then I did see that the officer said that he, based on what he alleged as Mr. Nunn's behavior and the evidence from the video, which we don't have here today, which they referenced some things happening on a video, that they went and got a search warrant. And so then that would lead me to believe, again, I don't have the video, that there might be some issues with the search warrant, and that all that was found was the fruit of the poisonous tree. If it's an invalid questioning, he's not Mirandized.
Okay, but what bearing does that have on his bond?
Well, I would say this. They reference certain things in the police report as a means to refute the bond. And I was not at the arraignment. I understand that the bond was set at $100,000. As I said, he has no prior record. In this situation, we're asking for a PR bond. If the court, because of the nature of these allegations, if you want to have a tether, we would say we'd have a tether, let him go to work, go to grocery store, go to doctor's appointments. I did talk to Reverend Green, and he said that he would work with him and talk with some of the other. I talked to Pastor Harold Wimberly, who works with the youth, who also said that he would work with him. But as I review the police report, I would say this too. This is not a situation. I'm not going to name the names that are in there, but they basically are talking about other people that are involved with certain activity and pictures of other people that are not him involved with activity it's not him being involved with that activity. This is a friend. One of them is a friend that he grew up with.
Okay. But I still got an answer to my question. You're saying there are internal discrepancies with?
Well, in the discovery, it says that he was questioned about I'm talking to him. It first says that he ran when the police came. He says that when the police came, he said he had worked a full day at his job, and we can get documentation to substantiate that. And that he came out to his car to get his charger. And then he was questioned by the police about where he lived. And that he says he told the police where he lived, and that he was not dishonest about where he lived. And they're also alleging that he said something about not going to the hospital. He did say that he went to the hospital to visit one of his friends from school who had been involved with the shooting. And that there was, so then the police were questioning him, and they were asking about searching his apartment. And then there was obviously some things that were found in his apartment. He said that he believes that somebody was let into his apartment and did certain things that he was not aware of, and that there's allegations that the items that were found in the apartment were involved with other offenses, which again, he has nothing to do with, has no knowledge of any of that.
I don't know for purposes of bond if it's something we need to get into, but who has access to his apartment?
So there in the police report, it says that he's the only one.
No, who are you saying has access to his apartment?
On the lease at the time, it's him and his girlfriend that are residing in the apartment. So it's the way the report is written is he's the only one that lives there. But at the time, it was himself and his girlfriend that lived at that. Not the current girlfriend, but a girlfriend.
I mean, am I to take then from your argument that as to what was located in the apartment. And certainly during this process, you can challenge it, but he's saying that wasn't his.
Correct.
And that it belonged to somebody else who would have access to the apartment, which would mean it belonged to the girlfriend.
Not the girlfriend, but he believes that the girlfriend allowed somebody else to access the apartment, and that the other person who was involved with, what's referenced in the report is that there was some kind of shooting, and his friend Sarah calls him up and says, hey, I was involved in a shooting and she was at the hospital. He said he went to visit her at the hospital. She was pregnant at the time. He says that she had baby clothes in her car and she wanted him to take the baby clothes. He took the baby clothes and then he went to his apartment. And then he said she was still upset and that she comes over there to meet him at the apartment and he's trying to calm her down and she's upset about the situation. But he believes that his girlfriend let her boyfriend in, and that it's the boyfriend's items that were found in the apartment, not his.
And it was who?
The boyfriend, Sierra's boyfriend.
All right. Anything else?
Again, I would just say I've known him all his life. I've never known anything like this. He did graduate from Ypsilanti High School. He's had a pretty solid work history. He worked before. I know he worked at the Noodles Company. I would often see him there. He does not have a criminal background. And his family is here. His father is here. His mother, she's working right now. Everybody is very obviously distraught. He's never had anything like this. He's upset about this because he's like, this is not me. He has assured me that this is an experience. He will not associate with the people he associated with before. He said this is one and done. I know the court and, neither of us are necessarily spring chickens. We hear stuff all the time, but
I'm a spring chicken.
You're,
I don't know about you, Mr. Boy. You can comment on your own age, not my.
I would just ask for him, and he said he's willing to take a lie detector test as well. So I'll just put that out there.
All right, response from the people.
Your Honor, the people are concerned because this matter does tangentially involve a shooting. The defendant lied several times to the police officers during their interviews. Even the story today that's been represented by counsel is an additional new story. He first said that he went by the hospital, did not stop his car, did not get out, did not find who he was looking for and left. Then when he was pushed back by the officer who mentioned surveillance footage, he said he stopped for a minute, looked around, still didn't see her, and then left. Now today he's telling a story where he did stop, he did find the vehicle, he did find who he was looking for. He was moving stuff back and forth between the vehicle that was involved in the shooting. Yeah, this is just a deeply serious matter where I have no faith that we're being told the truth.
And Your Honor, if I may respond again, I wasn't there. The prosecutor wasn't there. This police report was written up. This is my second time talking with my client about the situation. There has been, from my standpoint, consistency where he was saying that his friend called him in distress and he was trying to help comfort his friend who was pregnant at the time and has now had a baby. And there has been consistency there. He said that at the time he was questioned, he had worked a full day, he was tired. He said that he had no intentions of being dishonest with the police. He had no idea what was in his apartment. And he said that he has had some bad experience in the past with the police. So he did obviously, I think a lot of folks have PTSD, anxiety when it comes to the police. So, but what we have is we often get reports. A lot of times I get what's in the report, and then I talk to my client. The client will say, even when they give written statements and they sign off on it, they say, that's not what I said. That's why I typically tell clients, don't say anything. Don't say anything. Tell me the truth, but don't say anything to the police talk to me, tell your mama the truth. and then just zip it when you're dealing with the police and don't lie.
You would acknowledge that were he tied to what was found in the apartment, that makes him a danger to the community.
I would acknowledge that, yes.
And so I've got to then go on some limb to find that he's not a danger to the community because it's found in his apartment.
Well, if Your Honor.
And I don't, if I can just finish, please.
Okay.
But I don't have anything else that points to those items belonging to someone else.
Well, in the report, though, it does say that the items belong to Devon, to someone else. It doesn't say that the items belong to him.
I know.
It just says the items are found in his apartment.
But they're involved in a crime or crimes. And they are now in the defendant's possession.
In the defendant's and his girlfriend's apartment. Correct.
But how does that help me, Ms. McCoy?
If he has it.
If I have two people in an apartment, then are you saying that it's the girlfriend? I mean,
what we're not saying it's the girlfriend. We're saying what we believe is that the girlfriend let this other person in there and the other person put his stuff there. Put from the shooting.
Do I have anything that says that? I mean, other than the statement today, is there anything or any statement given that scenario occurred?
I would say that we would need to talk to the girlfriend to see what her statement would be and also talk to Sierra about what happened at the hospital. So, but I would say, again, Your Honor, I understand you. That's why we're saying if you put him on a tether, then we will know where he is. He's got to go to work.
It isn't the question of necessarily knowing where he is, although that becomes an issue. It becomes an issue of an assessment of this individual's threat to the community. That's what it becomes. And if the scenario that you have forth can give then one assessment to those items being in that apartment. But if the defendant is tied in or hiding those items in that apartment, that's a very different scenario.
Correct.
A very different analysis for the court as to what the court should do. But the part that would favor you would be if there's some indication that someone else let them in, that being his girlfriend, and that there's this other party that put these items in to his, and I say his possession because it's his apartment too, but puts it into his possession, then that becomes something very different. But I don't have that. I hear what you're saying, but I don't have that.
Right.
You acknowledge that if those items are tied to him, that he would be a danger to the public.
I would not say again, I wasn't there. I would say if
McCoy, you could try to sidestep it all you want.
No, Your Honor, I just want to make sure I'm clarifying for the record. If he was involved, if he's lying and if he was involved, what the complaint, the 123 pages of the discovery clearly, repeatedly say is that there are other individuals out there that are a danger to society. And the allegation against him is that he lied about what happened, lied about his apartment, lied about what happened at the hospital, and that there were items found in his apartment connected to what the other individuals did. And there's pictures and it's littered with indications about these other individuals. So what I would just say is that the presumption is that you're innocent till proven guilty. Although a lot of times in our society, you're treated as if you're
not going to try to give me that lecture.
Guilty till innocent.
I've been doing this way too long.
Right.
Don't try to give me that lecture.
Okay.
I just need to try to talk. I want to talk about his particular interactions.
Okay.
If all of these things had occurred as they were, and an individual, how should I say, participates in a cover-up of those crimes.
Right.
Would you consider that person then to be a danger?
I would consider it definitely would be a problem. If they're young, they're dumb. They shouldn't be, if they're an eagle, they shouldn't be hanging with the chickens because the chickens will bring you down. I would say that. He's 21, no prior record.
I hear that, but I also I understand. I'm sitting up there looking at this young man, and I realize he doesn't have a record. I realize all of those things. I also realize there's some very dangerous and tragic things that have occurred, and he has in his possession, whether jointly or by himself, the instrumentalities of those that help commit those acts.
I understand. Yes.
That's the problem.
Right.
And if he has them in his possession and participates in the cover-up of that, it really becomes an assessment of how dangerous then is this individual. Because you can be stupid and dumb and still dangerous.
Well, you can be young and dumb and make a mistake and go to jail, and then you're like, I don't like this. I'm not going to do it anymore.
Dangerous.
Well, I would say he's 21. The adult brain doesn't fully mature till the age of 26. Some people would say 30s for some folks. He has a job. He has an apartment. He said to me, all he does is go to work. He did get caught up with the situation. Even
Mr. McCoy, where would he stay if I were to release him?
if you were to release him, he could go back to his apartment, or if the court is saying, no, you're not going back there, he could stay with his parents, and they live in Ypsilanti, which I can give the court the address. I just don't want to put it on the record because of, I would rather just give the prosecutor and the court that privately. He has a sister that's in college in Detroit. He has another sister that lives in Columbus, Ohio.
So where would he,
His mom, I talked to his mom. She said that he could stay with her and his father at their residence.
Yes.
Briefly.
Okay. Like we had a planned conference, I'm gonna pass this matter. Mr. Coy needs to. Family in this case, so you can take him back. I'll call it up. We get Henderson.
Good afternoon, Your Honor. Nicole Sadi. I represent Miss Henderson, and she is now at the podium to my right.
Okay.
Nicole Henderson.
All right. I've received the assessment. Have the parties had an opportunity to view?
People have your one.
I have.
Go ahead. Any additional argument?
I'm sorry, I didn't hear the last
Any
few.
additional argument regarding her release?
Yes, would you like me to go first?
Sure, it doesn't matter.
Okay. So Your Honor, I see that I see that Ms. Henderson was extremely forthcoming with Mr. Statman during this assessment. While I'm looking at Mr. Statman's recommendation, these recommendations Mr. Statman are making include abstinence as well as outpatient treatment. I'm also looking at the law enforcement bond information form that I'm showing Mr. Cook right now. Thank you. Let the record reflect, I showed it to him. Looks as though the police, the day that she was arrested, considering everything that they saw on the scene, was recommending a personal recognizance bond along with the scram tether. My client is willing to wear the tether as she understands this is normally a usual part of bond on a matter like this, as well as engage in AA. I understand that upon reading this report, it may put to somebody's mind, well, Ms. Henderson has been to rehab before. And in terms of the actual nature of addiction and rehab, Your Honor, I would argue that that is what we see when people are breaking a habit. There is a recommendation in here that is something she has not done before. Ms. Henderson has not attended Alcoholics Anonymous before and had that type of support and ability to make some sober connections. She has never done that before. And it looks as if Mr. Statman believes, professional assessment, that she would be a good candidate to go ahead and receive outpatient treatment combined with these other recommendations.
Chairman, just two brief things. One, just a slight correction from what was just indicated about the information form. Where I believe the council was looking, that was the people's original recommendation at the time of charging something we pulled out, not the police. Certainly that was the charging EPA's recommendation. In the case, and when the case was first brought before this court, I asked for more than a PR bond for the reasons I indicated on the record. I know that doesn't factor into the court's decision today, but I just wanted to correct that. The second matter that, or the second piece that I wanted to discuss was in my review of the defendant's version of events as told to Mr. Statman, that they differ from what I believe the report and the evidence shows, not too dramatically, but in ways that I think it's important for the court to be aware of. Specifically, one part in the first paragraph indicates that the defendant completed field sobriety. She was only able to complete one of the three tests, to my understanding. The other two were not conducted or completed due to the defendant's lack of cooperation at that point. Admittedly, as the court's aware, she was incredibly intoxicated, so I'll just attribute that to her recollection of the event might not be the best. I don't think there was any malice on her part, but I think it's important for the court to have that corrected understanding.
I would like to respond. I will say that this is a paraphrase, and I would also like to say that Henderson.
Can I ask why you're going down the path that you're going down?
Yes, that he's paraphrasing that Mr.
But why are you
paraphrasing?
Why does go ahead?
Okay, there may be an inconsistency here, but that doesn't mean there's an intention to be inconsistent, is why I'm going down this road. I think you understand. I don't need to go further. The other thing I did want to address for this court's attention is while Miss Henderson acknowledges what the blood draw was, this blood draw was taken well over 4 hours after the initial arrest where blood alcohol rises. So it is not an indication of where her level was at the time of arrest.
So we're going to argue over those points?
Your Honor, in the bond argument we're making based on this report, I'm bringing forward based on science for my client to pursue.
Why do you think I asked for the assessment, counsel? Really? Why do you think I asked for the assessment?
Well, Your Honor, my job's to advocate for her.
And it'd be good if you did that, but why do you think I asked for the assessment?
I can only go by what you said. I'm not in your mind, but you said that you were concerned about my client's health. You're concerned about my client's mental health. You're concerned about her relationship with substances. And I believe you ordered the assessment because you wanted to be informed on those concerns before considering reducing bond. That's my belief.
Why can't I get arguments that go toward that?
This, in my opinion, this does go towards that. When we're looking at a blood draw this high, the science shows, and that
You know what? I mean, I'll let you go. I'm gonna do what I want to do because I've been trying to get Miss Henderson out. I've been trying to do it in a safe way. I've been trying to do it with as many safeguards as I possibly can get. Trying not to miss anything. That's what I'm trying to do. I don't know that the arguments you're giving me help me any way in that.
Your Honor, respectfully,
That means I'm going to get none. So go ahead.
Your Honor, that is extremely unfair. And on the record last time, you said something that was unfair as well.
You know what? This ain't about you.
That's right.
This isn't about you. It's
right.
not about you.
That is correct.
Stop right now. Deputy, take her back into lockup. Court's going to stand in brief recess.
All right.
Yeah.
14A, District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Jason.
You may be seated. Court recalls the case of People versus Anderson.
Good afternoon again, Your Honor. Raymond Cook for the people.
Good afternoon, Nicole Sadi. I'm present and my client is standing to my right.
I'm going to dispense with any further argument if that's what we want to call it. What I'm going to do is defendant's going to be released on a personal recognizance $25,000 bond. Prior to release, she must be placed on a scram tether. So, ma'am, you won't get released right away, but they'll come and fit you with a scram tether and then you'll be released. I'm going to order as a condition of her bond, your programming through, because you're employed at GM, right?
Yes.
And so I'm going to indicate also that the defendant is to engage with, is that GM or UAW program?
Well, it's called Rivers Bend, so I'm not.
It's called what?
Rivers Bend, the IOP program.
It's through GM.
Can I say something?
Hang on a second. I'll do it this way. That you're to engage with General Motors Employee Assistance Program, whatever their program is. You wanted to say something?
Yes, during my assessment today with Matt Statman, I had told him that I wouldn't mind. I would like to do the Dawn Farms program. That's $40 a week outpatient.
So here's what, so that we know. This assessment gives me one sort of side of you. All right. The Employee Assistance Program, I want you to engage with GM's Employee Assistance Program because it's available to you.
Okay.
Okay. I'll indicate that you're also to engage in Dawn Farm programming. I'll make that a condition of your bond, but I understand if one program is there, that might be a bit much, but okay. So I'll make that also part of the order. And then is there anything else from either side on?
Nothing from the people.
May we briefly approach, Your Honor?
Yes.
Thank you.
Oh, because it shows my face scratch. Best if we have a quick in chambers.
I'm pretty good, I'm sure.
Okay. All right. We're all set.
Thank you.
You're welcome.
Next matter is Nigel Ingersoll and Krista Carnahan, file 15-15991-DM, set for a show cause today. All right, I do see Ms. Carnahan is with us. Mr. Truce, do you want to put your appearance in?
Thank you, Your Honor. Richard Truce appearing on behalf of Mr. Ingersoll.
All right, this is a request by Mr. Ingersoll for order to show cause as to some missed parenting time in June. I believe the dates are 6/7, 6/14, and 6/21. I've reviewed the individual parenting time paperwork submitted by Mr. Ingersoll. I've also reviewed the response from Ms. Carnahan. Mr. Truce, have you had sufficient opportunity to be ready to proceed today?
Yes, Your Honor.
All right. I'm going to ask both parties to raise their right hand so I can swear them both in, then we'll begin with Mr. Ingersoll. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Mr. Ingersoll?
Yes, sir.
Ms. Carnahan?
Yes, sir.
All right, go ahead and put your hands down. Mr. Ingersoll, do you want to tell me what your requirements or what your request is and why you want me to do that?
My request would be to actually have my children at your order, and then the order actually be followed by the mothers.
All right. Have you spoken with Riot's counselor?
I have not.
Ms. Carnahan, why is it that
Yes, Your Honor.
Riot didn't see his dad, or what happened on June 7th, June 14th, and June 21st?
I had the visits were going okay. I had actually let him go 3 times in that week. The last week that he had him instead of just the one. I had been going to work more. And so Nigel would come and pick him up from here, and they would have dinner, and it was going all right. And then it went south. I went to pick Riot up from Nigel's. Nigel had put Riot in a headlock. Riot got mad at him, and then Nigel did it again. And I told Nigel, you have to stop. You're going to end the visit badly. We're just going to end it like this. Riot had came home, and then the following week, according to Riot, he didn't tell any of the kids that he was getting married. Riot and Nigel got into a yelling match outside. I made Riot come inside because he was just wearing a t-shirt and his underwear at the time. I gave him their space. About the following week, we were driving through Nigel's subdivision, and I asked Riot, would you like to stop and talk to your dad, see if you guys can hash this out? Riot said no. I gave him a couple of days. I asked Riot, will you call your dad? He told me no. I waited a couple more days, asked Riot again, hey, will you call your dad? He told me no. We waited a couple more days, asked him again. I finally got Riot to call his dad. It ended up in them yelling at each other on the phone. Riot hung up on him. And then the following week, Nigel showed up at the house. They got into another argument. Riot shut the door in his face. Riot's been talking it over with Pam. It's taken us weeks, and I think their last phone conversation went well. I think that Nigel seen that it was starting to go south, so he cut the conversation off before it could go south again. I took Riot to go see his counselor on Tuesday. And I haven't gotten a chance to talk with Nigel yet about it or Riot talk with him. We've been pushing for Riot to go back and see his dad, but he's kind of been dead set on not. However, Pam, myself, and Nigel, we got Riot to agree for Nigel to take him to Alpenfest for a few hours in a public setting. Riot was still pretty discouraged about it, but we ended up getting him to agree to do it.
We got him to agree?
Myself, Nigel, and Pam, Riot's counselor.
Okay. So what if anything has the counselor recommended other than this Alpenfest trip, as things are developing through the summer?
So far at the last visit, the only thing that she came up with was that Nigel take Riot on a Monday or Tuesday to Alpenfest because he has Monday off, give him a couple of hours in a public setting. And then she was going to meet with Riot on Wednesday to see how that visit went and go from there.
All right. Do you have any, Ms. Carnahan, do you have any opposition to the counselor talking directly to Nigel and try to kind of fill him in on where she thinks she's going? The court order says that we're going to go through May through July and then have a report from the counselor. But it sounds like things are kind of deteriorated a little bit more than I expected. And I think it might be helpful if Mr. Ingersoll can have some time with the counselor just to kind of find out where she's going. Do you have any objection to that?
No, absolutely not.
Mr. Ingersoll, what do you think about, or Mr. Truce, what do you think about that suggestion?
Your Honor, I don't have any opposition to that. I mean, the concern that I would express here to the court, I certainly understand at Riot's age, and with the circumstances that his relationship with Mr. Ingersoll may be strained at times. I don't think that's an uncommon thing for a teenager. I have concerns, though, that, the teenager here is driving the bus and basically dictating that he's not going to follow the court order. And I mean, it feels like when the court issues an order, it should be followed, and it shouldn't be the teenager dictating to mom or dad that they're just not going to follow their instructions or the court's instructions.
Well, that's one of the reasons why I set up in the original order that Riot was going to talk with his counselor on a regular basis, and I was going to have a review hearing at the end of July to see how things went. So the court can't be involved in micromanagement. So there does have to be some opportunity for the parties, including the child, to learn how to deal with each other again now that Mr. Ingersoll is back from his time in prison. And I knew that there was going to be ups and downs to that. So I set a preset time period for a review. It sounds to me, at least from Ms. Ingersoll's testimony, that she is making appropriate attempts to have Riot meet with his dad on a regular basis. And that's really all I can ask her to do. It sounds like there's been some rough spots between Riot and Mr. Ingersoll, including some headlocks and some yelling and screaming matches with each other, which are a bit disappointing. But again, I don't want to say it's normal, but they're going to have to learn how to deal with each other. Mr. Ingersoll is clearly wants to be involved, but there's a way to go about this appropriately. And I think that the counselor could help him at least understand Riot and Riot's needs, as I believe Riot does have some needs that are above and beyond the ordinary. And so we all have to learn how to do that. So my thought at this point, and I'll hear some argument again, Mr. Truce, if you wish, my thought is that Mr. Ingersoll have a short phone conversation with the counselor, and the counselor explain where she anticipates going. And I think this idea of going to a public place for Alpenfest could be a good opportunity to get some trust for both of them as we continue. And then we're going to have a review hearing sometime in August or September, once with that parenting time that's in the court order is already set up. So I think there's supposed to be a review hearing in August, if I remember correctly. And so we're looking at about a month or a month and a half at most of continued parenting time with the involvement of the counselor. So any comments that you have, Mr. Trush?
So just a couple of things that I would indicate from the court records, it looks like 8/14, maybe when that review hearing is set. At least that's what I show the next date to be. I have a couple points that I would clarify. I mean, I think, and I think Mr. Ingersoll agrees, the Alpenfest idea, I think it's a good idea. Mr. Ingersoll reports to me that he actually suggested that idea. In any event, I mean, I think that's a good idea. In the time period between now and the review hearing, I mean, are the parenting times going to continue to be ordered as scheduled?
Yeah, I'm not changing things. Again, I would ask Ms. Carnahan to make every effort to get Riot to go to those parenting times. On the other hand, if he's 13 and throws a fit, at some point I'll address that in the future, but I'm not going to do it on a daily basis. I don't think I can and should do it on a daily basis. I need to give both sides some ability to learn how to do this. Riot has some needs to know things ahead of time, but he also needs to know that he's got to go to his dad when the court says he's got to go to his dad. But that's a learning curve. So I'm not changing under these circumstances, I'm not changing the parenting time order. So mom is still required to try to get him to go. Dad needs to learn how to make that as easy as possible. And headlocks and yelling and screaming probably isn't the way to do it. So somewhere in between for both parties would be appreciated. And then we'll assess at that in August at the next court hearing.
And Your Honor, to the extent during these parenting times that Riot does want to stay with his father, because Mr. Ingersoll has reported to me there are times when he has asked to stay longer, is that permissible to make up for some of the lost parenting time?
I can't say that the lost parenting time is Ms. Carnahan's fault.
Okay, got it. I see what's going on here.
Mr. Ingersoll, do you have something to say to me?
Yes, I do, Your Honor. I see what's going on here.
Then say it.
That I think it is ridiculous, Your Honor, that you are saying, oh, she's got to make her best effort to make him come with me. I've put in 4, almost 5 parenting time complaints, and she is already not following your orders. Like, what do you mean? I show up and he's not even dressed, Your Honor.
Mr. Ingersoll. She is not violating the orders, Mr. Ingersoll. Your son is. Do you really want me to do something to your son?
Your Honor, you said last time we were in court that my son wasn't old enough to make those decisions, and now you're letting his mother just get away with not following your order.
No, I'm saying that he's at fault, but I'm not going to put him at being at fault. That you're exactly right. He's not old enough to make those decisions, but she has been following my orders. She
hasn't. No, she hasn't.
Mr. Ingersoll, who makes that decision?
I thought it was you, but apparently my son makes the rules.
Mr. Ingersoll?
Yes, sir.
Sit down and be quiet. Mr. Trush, speak to your client. I don't think he wants to be held in contempt. You ready to proceed, Mr. Trush?
Yes, Your Honor. Thank you.
Is there anything else that you want to argue on your client's behalf, Mr. Trush?
Your Honor, I just want to address the allegation that Mr. Ingersoll placed his child in a chokehold. Mr. Ingersoll reports to me that they were playing on the trampoline. They were wrestling around, which again is not an inappropriate activity to happen with a 13-year-old. I mean, that is the context in which this is going on. This is not, this is not how this is painted to be. Thank you.
Your Honor, I was there and witnessed it. It actually happened in their kitchen. Aloria was there too, along with another person sitting at the table.
All right. Be that as it may, I'm trying to give both sides enough room to knock off the rough edges and to have reestablish a relationship. I think we're making progress, and I won't know for sure until I hear from the counselor in another month. So, Mr. Ingersoll, I'm going to give you an opportunity after the month has been completed to have a full and fair hearing, if you wish, on anything that you want to have a hearing on. But the original order was set up so that we would have May through July as this testing out process for some initial contact, and then Riot could have his counselor address any of those issues from either side or from Riot. So that's what I intend to do. So I'm not taking away your right to have these things fully and fairly processed, but I don't believe that today is the appropriate time to do it. Hopefully, in the next month, you can develop an ongoing relationship with Riot. If not, we'll address it after the counselor has the ability to process it with Riot and submit a report. I would hope that you would take advantage of the opportunity to meet with or to speak with the counselor and put in your 2 cents so that the counselor can make whatever adjustments are necessary to assist you in having a relationship with your child. For now, I don't see any purpose served in changing anything. So the counseling and the parenting time will proceed as is in the current order, and we'll address this at the review hearing in August. Is there anything else, Mr. Truch?
Not for today's record. Thank you, Your Honor.
Ms. Carnahan, anything else?
No, Your Honor.
I'll see everybody in August. The next matter is Nigel Ingersoll and Cassandra Ingersoll, file 23-19438-DM.
She is not present. She's not logged on at all either.
Ms. Ingersoll is not present. It is now 2:22. This matter was set for 1:30. In the court's order dated 2/23 of 26, a review hearing regarding additional or ongoing parenting time was to be held on July the 10th at 1:30 in the Otsego County Family Court. So the parties have had notice of this today's hearing since at least the end of February. Mr. Truce, from your client's perspective, how did the parenting time with Roman go over the last few months?
So, Your Honor, in February, March, April, and May, Mr. Ingersoll traveled down to Tennessee, and I would say generally the parenting time there went well. I think there were some hiccups along the way, but ultimately I think the parenting time there generally went well. In June, Cassandra was supposed to bring Roman here to Otsego County, where Mr. Ingersoll was supposed to have a visitation here. That visitation did not happen. Miss Ingersoll went straight through to the UP, did not drop Roman off. So that visitation obviously did not occur as planned. I would suggest to the court, I think, that continuing to expand the parenting time and custody here is appropriate, working towards, I would say, 50-50 custody.
What do you suggest specifically?
So we would ask for summers and holidays at this time.
Well, going from a few days at a time to summers, when you say summers, what are you looking for there? The entire summer, every other week? I mean, the parties do live in Tennessee and Michigan, so it's a little difficult transportation wise with a young child.
So
Right.
that whole summer would be appropriate.
Right, and Your Honor, that's why that suggestion is made, because that way the transition period could essentially be at the beginning of the summer and the end of the summer, recognizing, again, we're halfway through this summer right now. But again, the visitations have gone well. And again, I mean, the only hiccup in this appears to be, and I hesitate to say bad faith on the part of Cassandra, but I mean, again, Mr. Ingersoll made the trip to Tennessee every time he was supposed to, at every opportunity he had to see his child. Uh, so again, I would ask the court to continue to expand, even if the court didn't order summers at this time. I mean, I would ask for extended visitations. Again, we're continuing to build trust and rapport here.
Roman is 4, right?
Yes, sir.
And you were out of Roman's life for a little over 2 years, is that correct?
No, sir, that is incorrect. It was under 2 years. It's like 22 months.
All right. That was the end of 23 to mid 25?
Yes, sir.
Did you have, Mr. Ingersoll, did you have any contact with Ms. Ingersoll as to why she was unwilling to drop off Roman on a trip to the UP?
I did. She called me. She called me 2 minutes before I was supposed to pick her up and threw a fit over my plans for the day. When she planned on dropping her off, even though it was supposed to be a supervised, she told me that she couldn't do your ordered 5 visits. So she was going to give me 2.5 days unsupervised, and I was fine with that until she decided she didn't like my plans for the day and she didn't let me have my daughter.
What were your plans for the day?
I mean, it's irrelevant, but I was attending a wedding ceremony.
Yours?
It was.
Did you tell anybody about that?
I did. And I thought it was a gift from the universe that my daughter's mom was going to drop her off hours before I was supposed to get married. I took that as a little gift from the universe that just got ripped right away from me because obviously neither one of them respect your orders.
Well, Ms. Ingersoll is going to address the court for her failure to appear today. I'll deal with that on a separate basis.
And Cassandra has blocked all my phone calls, so I don't have any contact. I messaged her and asked if I could talk to my daughter, and she said no, and she cut me off.
Mr. Ingersoll, when does Roman begin school?
I'm assuming August is Tennessee school year.
Will she be 5 this year or next year?
She'll be 5 in December.
What is the normal cutoff for school? November? For being 5 in kindergarten? If she's not 5 until December, they may not let her go to school this year. I don't know what Tennessee law is, but Michigan law, my memory is if they're not 5 by November, they typically don't let them go because they're too young.
They do have an early head start, Judge.
Yeah, she
There
may
a
be
head start
eligible for
issue.
like a, yeah.
But she
Right. Yeah, so I hesitate if she's living in Tennessee with mom to give you ongoing, to make a schedule right now for ongoing past the summertime. without knowing that kind of information about what her school time looks like. So I can give you 2 weeks in August. That would give everybody time to plan it and to make arrangements for the transportation. But to go much beyond that, all right, here's what I'm going to do. 2 weeks in August. Phone contact 1 time per week. Alternating holidays pursuant to the 46th Circuit Court long distance schedule. And a review hearing. Let's put it in April of 27 regarding summer parenting time in 27. So you get your time for a couple of weeks in August for this summer. That will be here in Michigan, unless you want to go down to Tennessee. I'll leave that up to you. But
Your Honor, I've been down there. I've been down to Tennessee 5 times. I think it's time for her to come up here.
I kind of figured that, but you're going to have to make arrangements for transportation. That may mean that you have to meet her halfway, or you have to go down once and talk it over with your attorney. But you're going to have to work that out. So 2 weeks in August, phone contact once a week, ongoing, alternating holidays pursuant to the 46th Circuit Court long distance parenting time schedule, and a review hearing in April to get ready for the summer of 27. And we'll discuss what that means as far as parenting time at that time based on how things go so far. Mr. Truce, would you prepare that order and submit it to me, please?
I just want to make sure that I have everything. So phone calls once per week, alternating holidays pursuant to the court's parenting time calendar, 2 weeks in August. Is it just 2 weeks, or is there a specific time period we're setting?
No, 2 consecutive weeks. So that I don't want the child bouncing back and forth. So that's kind of what I gave him, a little longer period of time, so the child only has to come up once and go back once. At 4, that's a huge issue for the child moving that much. So I want to do it once and have him have sufficient time to develop a relationship with her. So 2 weeks here, consecutive. It doesn't matter to me which weeks he picks, but we'll leave it at that.
Okay. And then review in April of 27 for summer of next year.
Correct.
I think I can handle that, Your Honor.
All right. Good luck to you, Mr. Ingersoll.
Thank you, Your Honor.
That's all for today.
Like, it's big medicine. Has everybody read the evaluations of that? And I think we're kind of left with that. And Mr. Petter, Brandon, we're at the sanction hearing. But those 2 matters, are we going to see those folks, or what are we going to do?
And I would defer to defense. Ms. Kamiri, if I'm not mistaken, indicated in both of those that restoration had been ordered in Olympia cases. So I had prepared restoration orders for Lacey, but I defer to the defensive.
Yeah, I am a little bit, we are expecting them, Your Honor. And I'm a little bit confused where we are at procedurally in Lacey, because these individuals aren't held.
So as to Ms. Big Medicine, we got a competency report back, not competent. And we have a long history. We understand more about Ms. Big Medicine than others, just because she's been on mental health court for so long, graduated from it, and things kind of went downhill. And Olympia, restoration was ordered. We need to and here it wouldn't be surprising to order restoration, given the history we have of her and what these crimes are, and then set a hearing date to give them an opportunity to see what they can do, because she has been restored before, if I remember correctly. And that would be into August, like August 6th. Yeah, this is Big Medicine.
Yes.
Hello.
Hi.
And Mr. Swenson.
Yeah, on this
where-
one, Your Honor, defense, again, I'm standing in for Ms. Kamari. Defense is not agreeing to the restoration order. I understand Your Honor may still order that, but ultimately at this stage, Your Honor, I do have concerns about the timeline. Ms. Kamari wanted me to raise or to move to dismiss today. Ms. Big Medicine's not held on this, but she has been in custody pending competency in Olympia, and the matters have kind of overlapped. And that restoration order in Olympia, Your Honor, my understanding was signed June 11th, I think. And she's just been held at Nisqually now for 3 weeks, over 3 weeks. So it's defense's position that it hasn't been timely and that she should have been transported to Western for restoration at this point.
And again, Your Honor, that's an argument based on a different case with different parties. So Lacey objects to a dismissal and would ask that a hearing be set 7 days from now.
Well, okay. On this case, we have a competency evaluation. Let me get back to that issue, but as to the competency evaluation and the charges and what we understand from Western State Hospital. So the timelines here have been just fine, in my opinion. She's had the evaluation June and there we go.
And I know in the last case where restoration was ordered on a Lacey case, the person was picked up within 7 days, Your Honor.
But as to restoration, is the city asking the court to order restoration?
Yes, Your Honor.
Okay. And as to restoration itself, is there an argument as to why the court shouldn't issue restoration given eligibility or what we understand from the competency evaluation from the defense point of view?
Yeah, at this stage, Your Honor, I think I'm working with limited information, but I guess there's no dispute that these are serious charges, but I do think it's appropriate to set a compelling interest hearing within 7 days.
All right, well, let's do that. Gives everybody time to kind of review things. Let's see, when can we do that with everybody present? All right, so we're gonna have a little more of an argument about what the court should or shouldn't do. When can we do that? We could set this on Tuesday, the 14th.
Yeah,
Okay.
that would be my request.
Okay. And at that stage, city can put their compelling interest out. I think probably best to put it to writing, get it to defense. Says what you're saying. If defense has something to respond to, it's always good to get it in, by Monday so the court can read everything. And
I have a trial tomorrow and Thursday, so I'll do my best.
I know, but unfortunately these timelines were set pretty tight. So we're going to be back. I'm going to set the 1:30 calendar and just with caution. We're going to set also track down what Olympia is doing, but maybe on a different day. But we'll be back. I'll set the 1:30 calendar notice, and the argument will be had that day about is there compelling interest, and then the response to that. Okay. So we'll be back next Tuesday. So Ms. Big Medicine. We're going to be back to talk more, and you have another hearing coming up as well with Olympia. So we're going to see a lot of you as we.
Well, I just wanted to let you guys know that my mom, she has on her background check, it says that I'm a missing person. She kidnapped me my whole entire life. And so if you do on her background check, it'll say Lori Big Medicine is wanted for kidnapping Jahan Big Medicine. And she's also DB Cooper, and the FBI is interested in her. I know that you guys are paying the cops and paying off the judges and everything, but just know the FBI does investigations, and whatever you're doing with the cops, I know that you don't like me because I'm attractive and that I've been raped, and that's why you're a judge, and that's why you're being mean to me. This town, Olympia, is not real. So I don't know how this court is gonna work, but just know that they know that my mom is mentally ill, and they know that she has a mental illness that no one else has. And they are interested, everybody's looking for me. I'm a Rothschild, my family is rich, and I'm being held hostage because my dad owns the World Bank. So everyone is looking for me right now. They're watching you and they know that you're wanted, and you're also kidnapping me. And you're very cruel to me because I've been raped and I have a hard childhood. And you know that, and you're very proud that you have been cruel to me my whole entire childhood because of the way I look, because I'm attractive. So just know that I'm a Rothschild.
So we'll see you in another week.
And I'm also being
And you
monitored.
can just knock on the door and they'll let you out of the booth.
So
All right,
I know
they'll just
I
let
didn't
you
do
out of the
anything to
booth
my
when you knock
mom.
on the door.
I didn't do
All right,
anything
thanks,
to
Miss
her.
Big
I
Medicine.
was
We'll see you in a
kidnapped.
week. Hope things are better then.
Well, just
We'll
look
see you
at
in a
her
week.
background check, okay? Just look at Lorraine
Yeah.
Bigman's background check and you'll see that she's wanted for kidnapping
Okay,
me and that I'm
I'm
a missing
hearing ya,
person and people are
but
looking
it's
for me.
time to
And that
go.
this town, Olympia, Washington is not
Time to
real.
go. We're done with our hearing, Miss Big Medicine. We'll see you soon. Okay, so long. And in the Lacey booth, your name in blue?
Me?
Yep.
I'm
Your
Tiffany
name?
Austin.
It's Austin. Okay, I wonder if we're gonna need Miss Crisco for that. Do you need some more time, Miss Crisco, to work on your other matter? That's all right.
It is for Miss Austin's matter. I am sending the 1077 right now if I can locate where I put it. Oh, there it is. Okay. Okay. Just sending
And
it
did you
over
have a
right now.
chance? Did you have a chance to talk with Ms. Austin, or did someone else?
I was able to talk to Miss Austin.
Okay, and you put in the, I think it's like page 2 or 3 for Western State evaluators to know what you're thinking, why you're asking for this, and I'll be able to see that.
Yes, Your Honor.
Okay, and let me turn to the prosecuting attorney here. Is there anything else? I see this is the only thing on a record. Is there any other record or anything else to know?
Yes, let me see, she did have, I think, one thing out of state. Just a second to put that up. Your Honor, I see out of Georgia, I don't see anything within the past 10 years, but in 2011, she had a theft by shoplifting that was on pretrial diversion. In a 2015, also out of Georgia, DUI, it looks like a disposition was deferred.
Okay, so nothing here in Washington. All right, and then Ms. Crisco, you've already sent that over? Somehow?
I did. I hope I sent it to the right person.
I don't know. Where'd you send it?
I've sent it to Miss Lopez and also Miss Eddy.
Well, it should go to Ms. Eddy, but the court, do you have it there? Hasn't come in yet. Well, Ms. Crisco, can you put on the record why it is you think that the court should sign this order?
Your Honor, there were, in talking with Miss Austin, there's indication that she is not in a safe place. She's being watched over, from my understanding, by the Miss Williams and Mr. Birch, that she has a lot of concerns about safety videos, also being
It's the entire lot. Sorry. Can I?
Okay.
Sorry, go ahead.
Well, Miss Austin, maybe I'll just talk to you. So what's going on here?
Yes, ma'am. I've been staying on this private lot that I was recommended to stay on for safety. I came to Washington about in October, and I was trafficked in between two homes in my hometown, and I died. I came back to life. I was sex trafficked, and I fled for 2 years. I finally made it to Washington because there was nowhere else to go. I was followed across the states and have been sleeping in my car, and was recommended to sleep on the lot, the safe lot at the Lacey Police Department parking lot, because I had somebody stalking me that was following me with military cloaking equipment. He was in the Navy. He was actually somebody that reached out to me to help me online through the situation and ended up trafficking me even more. So I was recommended to stay there. When I first started staying there, everything was fine. We were supposed to stay there from 9 to 7, so 9 p.m. to 7 a.m. Then you leave during the day. Well, the whole lot was recruited. People started showing up at night. They were doing these rituals, and they were recruited to basically profit off of torturing me on a pay-to-play website, a black web website. Well, in these two homes in 2022, I was implanted in my ear, in my butt, and potentially a brain through Synchron and BlackRock, because that's who the guy that
Let me ask you a
trafficked me.
question.
Yes,
So
ma'am.
when did you get to Washington?
I got to Washington in October of last year.
Okay. And have you had a home to call your own since then?
No, I've been trying to get one, but I have been in transition of that. I've been on a waiting list for that. My car is built out. My initial plan was to travel and vlog in my car, and that's why I had a built out car, but it didn't work that way. So no. I don't have a
So, all right. And then the next question is, so you're charged with this allegation of a simple assault by the city of Lacey. And that's why right now you're in jail, because we have hearings from the jail for that. So
Can I explain to you what happened with that?
well, it's not right now. Hang on a second. I have some more questions and then we can kind of move forward. But have you ever been diagnosed with anything like that would need a mental health intervention?
I'm all cleared. I am all
Okay.
cleared. I have doctor's visits and doctor's notes, and I have psychiatrist, and I have actually have my doctor canceled on me just yesterday for the implant, for the referral for that implant. I'm looking at one for the gastro, because I have some, like, they're able to inflate air into my stomach and into my butt. So there's one there. So I have a colonoscopy coming up just next week. And then I have another doctor's appointment for the implant in my ear.
So then you say you had a psychiatrist that you were working with?
Yeah, the psychiatrist cleared me.
Why? Was there some sort of
Because I have
diagnosis?
ADHD. No, I have ADHD.
ADHD? ADHD. Okay. All right. But other than that, you've never had any diagnosis of any kind. Okay. You just got these other issues that you need to see certain doctors for to get the implants taken out.
Yes, exactly.
Okay. All right. Okay.
I also have
yeah.
gastrointestinal problems from, I had an illegal surgery done on me that they took me underground, but they drugged me, poisoned me, and messed up my stomach lining. So that's kind of tied into like the air inflating in my stomach. But other than that, those are the only things that I'm seeing the doctors for.
Okay. All right. So this is the deal. I'm going to set another hearing for now. I'm asking, it looks like, let's see, kind of looking at some. All right. And so I'm going to give you a court date, and then you got to come back to court. You're going to get released today.
Okay. Thank you.
But you got to come back to court, and we're going to figure, I'm going to talk to my clerk about that court date.
Okay.
I need one in. Oh, yes. I'm appointing an attorney to represent you. And all right. And then, let's see, 3 months out would be October. Let's appoint. All right. So I'm going to write this down for you. October 6th at 10. It's 3 months out. I don't have a mailing address for you. Do you have a cell phone that we could send you a text message reminder? We're not going to say it on the public line, but do you have that?
Yes, ma'am. I can give you that.
Okay. Ms. Grisco, did you collect that information or?
Yes, Your Honor, I did just put it in the chat.
Okay, so I'm gonna hand you notice for October 6th, 10 o'clock. You're back in the district court here, Thurston County District Court, or City of Lacey. And you've got an attorney from Ms. Briscoe's office. One of the attorneys there will be yours.
Okay.
And all right.
If the city could be heard on release conditions, Your Honor, I may.
Well, probably go, where are you on that?
We'll
Have you
stipulate the
reviewed that?
probable cause.
Okay, all right. And what are you requesting?
Well, Your Honor, this happened in the parking lot in front of the library. And so the city is asking for conditions of no violations of law. I have requested an anti-harassment order to prohibit the defendant from having any contact with Katie Mae Williams. I believe, I understand correctly, they were both kind of sleeping or staying in the parking lot across from the library. I would ask that the defendant not be allowed to go back there, so that the address for that is 420 College Street, Southeast.
That's the Timberland Library.
Yes.
All right. And then I do see this request that I sign an order preventing contact with a Katie Williams and Ms. Briscoe.
Your Honor, due to my worry with her understanding, I'm concerned that inadvertently having one imposed is going to be confusing, and that she won't know the conditions or the limits that she has to follow in imposing an anti-harassment order.
Not only that, can I speak?
Well, one second, let me hear from the prosecutor for a second here.
Okay.
Has there been anything more other than the at the time of the arrest from Ms. Williams?
No, Your Honor, it's not a domestic violence crime, so our advocate doesn't reach out to the.
I just wondered if there was anything else.
Yeah, I don't have any additional information for this.
All right. That's what I'm gonna do. So Ms. Austin, you don't go back to that Timberland Library there at 420 College Street, all right, where this all is alleged to have occurred. Don't go back there. And don't violate the law otherwise. But we'll be back. I'm not gonna issue this anti-harassment order. Ms. Williams is she does have the ability to go to a court and ask for it, other than this criminal case. Given the competency review, I'm not ready to issue that anti-harassment order, but probably best to stay away from her if you think that she's not someone acting in your interest, nor. So we're going to be back on October 6th. Yeah, October 6th at 10 o'clock here at the district court. And you'll be released later today with all of this information, all right?
Okay.
Okay, that's it for today then.
Okay. Thank you.
You're welcome.
Am I good to go?
You're good to go. Yeah,
Okay.
knock on the out of the booth.
Okay, thank you.
I am sure with that competency review, she's absolutely going to show up at the competency review. Now she's getting out on a PR bond. There's absolutely no reason to think that she might not show up at the competency review, because possibly the implants in her posterior were telling her to not show up at the competency review. That's definitely not something that could happen. Wow. All I could think there towards the end was, what? In the butt? Sorry. If you know, and I apologize. I will be seeing myself out now. I want to say a very hearty thank you to Marty, CE4301, Darth Steven, who strolled in as if he was on time, He's always on time. Don't let him fool you. Thank you very much for your super chat. We had the pause in the super chat also today. Happy Saturday, happy Catterday. And yes, Miss Natasha Kitty, I believe those were teardrop tattoos that we saw with Mr. Ingersoll. Oh, Darth Steven, dropping the bye a little early. We'll get there. Get there. Not quite there yet. I do want to roll my credits because, you know, what I do. Look who's at the very top right there. Darth Steven, the Objectioner. Vegas Starlight, Natasha Kitty, thank y'all so much for your super chats today. Rhonda, Kiernoff, Becky, Granny, Mama, Felix, Ginger, Mary Beth, all of you guys chatting so hard, keeping the chat busy. I really appreciate it. Tonight, ladies and gentlemen, we do have that Judge Webster I was teasing yesterday. I'm getting that ready as we speak. Be looking for the premier link to go live just anytime now. I also have a Judge West case that's like 8 hours long. It's spread over 3 different days. I kind of want to show it all at once, but man, I just don't know if I got it in me. We'll have to talk about some of that later. We'll figure out when we're going to watch that, and we'll have something to watch tomorrow. I may go crazy and actually go live at like noon tomorrow and stream that thing until it ends, and then just like redirect directly into the premiere, because we are having a premiere tomorrow, and it is a Judge Stevens case. It is an interesting one. It is a motion to revoke probation. I think it's really interesting, but we'll see how it goes. We'll see how it goes. We're not live tonight, Vega. We're not live tonight, but we are doing a premiere tonight. The premiere, with premieres, we will have a live chat. So come on by, because the chat will be live tonight. That's why we do the premieres. But this is a good one tonight, ladies and gentlemen. I did not fix that. I thought I fixed that. I gotta look at that later. Anyway, kids, I'm your lone Wafusel. And again, I do want to say thank you for being here, and I will see you next time. I am... What is it I say? I am... it's too cheesy. Bye. I'm out. And remember, only you can take a bite out of crime. Bye! Never trust a good end screen. What? In the butt? Get out of here. I don't have anything else. Not even a Ferris Bueller reference. Bye!